Hello everyone and welcome to another episode of Legal Curiosity. Hope you guys are safe and healthy. Today we are going to understand the difference between a civil wrong and a criminal wrong. We will learn the basic difference between them with 6 points and will go to as much detail as we can. We have also introduced a new concept called Law Students Booster. This is something we have started for the law students to get additional information on topics that we'll be covering. This would ensure our videos remain relevant to the legal fraternity as well. So let's start. We should know that broadly a wrong act is either classified as a civil wrong or a criminal wrong. So let's first understand what is a wrong in the eyes of law. All the citizens and residents of India have many rights that has been given to them by the Constitution of India. Even migrants without documents from other countries have certain rights. Now, what rights do they enjoy is a topic of discussion for another video. The idea here was to give you an overview that everyone enjoys certain rights. Now, simply put, a wrong is a violation by one individual of another individual's legal rights. Now that you know what is a wrong in the eyes of law, let's get a little deeper and know what is a civil wrong. A civil wrong is an act that an individual commits against another, giving rise to a cause of action for damages and other appropriate relief. But then, what is a cause of action? A cause of action is a set of facts sufficiently to justify a right to sue. On the other hand, a criminal wrong is an act that a person commits against the state. Here, state does not mean the political boundary like Maharashtra, West Bengal or Karnataka. The state in legal context means either central or state government. Breach of a contract, defamation are some examples of civil wrongs. Murder, rape, kidnapping are some examples of civil wrong. Second, civil cases are filed by the wronged party who represent their own case. Criminal cases are prosecuted by the state and the prosecutor and not the victim files the case in court as the representative of the state. Now, you might be thinking, even in case of a murder, a victim's right to live and many other rights were taken away. So, why is it called a criminal act? Our law recognizes the right of the victim. Victim's lawyer can also participate in the proceeding along with the prosecutor, but only a prosecutor can file charges. We have our first law students booster here. Let's just get a little off topic and know who is a prosecutor. In India, public prosecutors are appointed under the provisions of section 24 and 25 of the Criminal Procedure Code. A prosecutor is an agent of justice and acts with the directions of the judge, and the state government appoints one in each district. Okay, now let's get back to our topic. Since murder is a common thing, we all know that it is a criminal act. But on a more basic level, how do we differentiate? Why are some offences against the state called criminal offences? If someone commits an act that is considered a threat to everyone in the society, those acts are classified as criminal offences. Consider the case of your neighbor. Let's name him Mr. A for the purpose of this example. If you get to know that he is someone who has recently failed to fulfill his contractual obligations to a second party, let's name the second party as Mr. B. Will it affect you in any way? No, it won't. It is only a problem for Mr. B, who on free will entered into a contract with him. But consider a second case. If you found out that your neighbor Mr. A has murdered someone, now that would create a sense of fear within you. You are afraid since he is capable of doing a dangerous act. Now, since he is capable of doing life-threatening acts, now he is considered as a threat to everyone in the society. That is why, to protect the society as a whole, the state has a duty to apprehend him. That is why it is not the only right of a victim to get that man arrested. It is also the duty of the state to protect its own citizens. Next, we'll see who has the burden of proof to prove in either of the cases. In a criminal case, the burden of proof is on the prosecution. It simply means if Mr. X accuses Mr. Y for the murder of someone, Mr. X has to prove Mr. Y killed that person. We have all heard the common phrase, innocent until proven guilty. This phrase in real life is used here. In a civil case, the burden of proof is on the claimant. This means if Mr. X claims a property which Mr. Y is enjoying, Mr. X has to prove his ownership. Here we have our second law student booster. Prosecution has to prove beyond reasonable doubt in case of a criminal matter. The standard that must be met by the prosecution's evidence in a criminal prosecution is that no other logical explanation can be derived from the facts except that the defendant committed the crime, thereby overcoming the presumption that a person is innocent until proven guilty. So, next, there are different courts for both civil and criminal offences. Civil matters are filed in civil courts. Some examples of civil courts will be Principal Junior Civil Judge Court, Senior Civil Judge, District Court, High Court, and Supreme Court. Criminal matters are filed in criminal courts. Some examples of criminal courts will be Junior Magistrate Second Class, Junior Magistrate First Class, Sessions Courts, and we have the High Court and Supreme Court. Next, we have the fifth difference. There are different remedies that are available for both civil and criminal matters. In civil case, one can claim for damages or injunction. In criminal case, the remedies that are available are one can be fined, one can be sent to prison, or can be asked to do community service. Yes, community service does not only happen in Western countries, it can happen in India too. An example of community service in India is the case of Sumit Kumar in Delhi, who was convicted for drunk driving, was asked to undergo 15 days road safety training and then help traffic police to combat other offenders against traffic violations. Let us briefly know the two technical terms that we heard in civil remedies. The first was damages. Damages referred to a form of monetary compensation due to a breach, loss, or injury. For example, if you found an insect inside a soda bottle, you can claim for monetary compensation against the soda manufacturer. The second was injunction. An injunction is granted by a court where one party is required to do or to refrain from doing a specific act. Now let's take an example for an injunction. Bob and Lisa, who were married, had a valuable collection of art. They are now divorcing and cannot come to an agreement as to who gets the collection. Lisa says to Bob she is planning to move to another state and take her art collection with her. Bob may file a petition to the court for an injunction prohibiting Lisa from taking the art out of the state before a judgment on the divorce is made by the court. Okay, that should clear the air. Next is a very interesting topic. Can a person commit an act which has both civil and criminal liability for the same act? The answer is yes. Some actions involve both criminal and civil matters. For example, assault can be both a civil matter and a criminal matter. It is a criminal case because when one person intentionally strikes and injures another individual, he has committed a crime in violation of the penal code. At the same time, if a victim of the said crime receives injuries and experiences pain and suffering, he can sue the person who caused the injury in civil court for monetary compensation for his medical expenses, pain, and suffering. Here is our third law students booster and final topic for this episode. When can a civil court issue a warrant for arrest? According to section 32, the court may compel the attendance of any person to whom a summons has been issued under section 30 and for that purpose may issue a warrant for his arrest. The prerequisite of this provision is that such a warrant can be issued only against a person against whom summons has been issued under section 30. Section 30 speaks about issue of summons. It can issue summon for the delivery and answering of interrogatories. It simply means when opposite party has placed some questions, the court may issue a summon asking the other party to answer it in the appropriate manner. It can also issue summon for the admission of documents and facts. It can issue summon for the discovery, inspection, production, impounding and return of documents or other material objects producible as evidence. It can also issue summons to persons whose attendance is required either to give evidence or to produce any documents. It can also issue summons for any fact to be proved by an affidavit. A proper format of warrant for arrest is given in Form 17 of Appendix B of CPC. So, this is it for today's episode. Stay connected with us to get more such useful videos. Hope you guys got a basic knowledge about what is a criminal act and what is a civil wrong. If you found this video useful, do like, share and subscribe to my channel Legal Curiosity. Adios amigos.